Αγαπητοί συνάδελφοι και φίλοι, καλώς ήρθατε και στη σημερινή 8η διάλεξη του δεύτερου κύκλου διαλέξεων για τη διαμεσολάβηση, που η Ελληνική Ένωση Διαμεσολαβητών διοργανώνει μαζί με τον ΟΠΕΜΕΔ. Σας ευχαριστούμε πάρα πολύ όσοι παρακολουθείτε σήμερα και όσοι έχετε δηλώσει συμμετοχή σήμερα. Είστε εξαιρετικά πιστοί. Σας βλέπουμε σε όλες τις διαλέξεις. Αυτό είναι ενθαρρυντικό για μας, όπως το λέω κάθε φορά, διότι δείχνει ότι η προσφορά μας βρίσκει ανταπόκριση. Εν πρώτης, να ευχηθώ σε όλους και όλες καλή Άνοιξη. Η Άνοιξη μπήκε χτες, 21 Μαρτίου, και όχι την 1η Μαρτίου, χτες που ήταν η αρινή ησημερία. Εύχομαι λοιπόν να είστε όλοι καλά, να προσέχετε, θα έρθουν βροχές και καταιγίδες, μην παίρνουμε ότι έχουν λίγο χαλαρώσει τα μέτρα, να προσέχουμε πάρα πολύ για να είμαστε καλά και να φροντίζουμε να εμβαθύνουμε στη διαμεσολάβηση πολύ περισσότερο από την ΙΑΣ. Το λέω αυτές τις τελευταίες φορές, το λέω κάθε φορά, ίσως λίγο να σας στεναχωρώ, αλλά εγώ φροντίζω και η διάθεσή μου και η πρόθεσή μου είναι να σας παροτρύνω να πάτε λίγο βαθύτερα σε έναν θεσμό ο οποίος έχει πάρα πολύ βάθος, διότι άπτεται της ανθρώπινης ψυχολογίας, των ανθρωπίνων σχέσεων. Γινόμαστε καλύτεροι άνθρωποι με τη διαμεσολάβηση. Βελτιώνουμε τις σχέσεις μας σε όλα τα επίπεδα. Διατηρούμε, βοηθούμε την κοινωνία να κρατήσει μια ισορροπία και μια ειρήνη. Βοηθούμε τις σχέσεις των ανθρώπων να προοδεύσουν. Οι επαγγελματικές σχέσεις, όταν μια διαφορά λύνεται με διαμεσολάβηση, το ξέρετε, είμαι βεβαία, όταν μια διαφορά λύνεται με διαμεσολάβηση, υπάρχουν ακόμα περιθώρια να συνεχιστεί αυτή η σχέση, ιδίως αν είναι μια συνεργασία, για την συνέχιση της οποίας έχουν συμφέρον και τα δύο μέρη. Αυτά είναι θέματα τα οποία δεν μπορούν να συμβούν κατά πάσαν βεβαιότητα σε μια δικαστική διένεξη, διότι σε μια δικαστική διένεξη έχουμε κάποιον ο οποίος νίκησε, για να το πω έτσι απλά, και κάποιος ο οποίος νικήθηκε. Δεν είναι αλήθεια, αλλά έτσι το εκλαμβάνουμε. Δεν είναι αλήθεια, διότι καθένας θα έπρεπε να αναγνωρίζει ότι δεν μπορεί να έχει δίκιο μόνο εκείνος, κάποιες φορές πρέπει να έχει δίκιο και ο άλλος. Σε κάθε περίπτωση, είμαι πάρα πολύ ευχαριστημένη που βλέπω να ανοίγει δρόμο η διαμεσολάβηση. Σέργε, θα δείχνεις και εμένα ή θα ακούγομαι μόνο? Σέργε.
Είναι speaker view, δεν ξέρω. Εγώ σε βλέπω που μιλάς. Εγώ σε βλέπω που μιλάς.
Με βλέπεις?
Πώς σας βλέπω?
Ωραία.
Αυτό που μιλάει φαίνεται. Τώρα εσύ γιατί δεν βλέπεις τον εαυτό σου, δεν ξέρω.
Όχι, εγώ δεν πειράζει. Δεν θέλω να βλέπω τον εαυτό μου, αλλά βλέπω άλλον συνάδελφο και λέω μήπως δεν με βλέπουν οι άνθρωποι και λένε τι έπαθα. Λοιπόν, συνεχίζω λέγοντας ότι η Ελληνική Ένωση Διαμεσολαβητών, η οποία ιδρύθηκε το 2010, λίγους μήνες πριν να ψηφιστεί ο νόμος 3898, που ψηφίστηκε το Δεκέμβριο του 2010 και ευθυγράμμισε την νομοθεσία μας προς την Ευρωπαϊκή Οδηγία 52-2008, η Ελληνική Ένωση Διαμεσολαβητών, λοιπόν, δημιουργήθηκε εκ του μηδενός, χωρίς καμία στήριξη από πουθενά. Είμαι υπερήφανη που το λέω, ανοίξαμε δρόμο και πάρα πολύ καλό δρόμο, μόνοι μας, χωρίς καμία παρέμβαση ή στήριξη, το επαναλαμβάνω με επίφαση, καμία στήριξη από πουθενά. Μπορέσαμε και δημιουργήσαμε μια εξαιρετικά καλή θέση με το Υπουργείο Δικαιοσύνης, το οποίο αναγνώρισε τις προσπάθειές μας. Στην πρώτη διάλεξη που έγινε το Σεπτέμβριο, στις 14 Σεπτεμβρίου του 2020, παρέστη ο ίδιος ο Υπουργός Δικαιοσύνης, μας έκανε τη τιμή να παραστεί. Οι διαλέξεις αυτές είναι υπό την αιγίδα του Υπουργείου και είμαστε πάρα πολύ ικανοποιημένοι που μπορέσαμε να δώσουμε σχήμα και μορφή σε αυτό το εγχείρημα, προσκαλώντας και αλλοδαπούς συναδέλφους από το εξωτερικό. Οι συνάδελφοι που προσκαλούμε είναι επιλεγμένοι με πάρα πολύ μεγάλη προσοχή, βάσει των ικανοτήτων και της εμπειρίας τους, και θα ήθελα να σας παροτρύνω να τους παρακολουθείτε με εμβρήθεια και να προσπαθείτε να κάνετε κτήμα σας αυτά τα οποία λένε. Δεν είναι για την ΙΑΣ, δεν αφορούν για την ΙΑΣ. Ξεχάστε σας παρακαλώ λίγο την ΙΑΣ, δεν έχει καμία σημασία. Η ΙΑΣ είναι μια διαδικασία, είναι μια διατύπωση η οποία ως στόχο έχει να οδηγήσει σε μια εθελούσια διαμεσολάβηση για να μπορέσει να γίνει προσπάθεια επίλυσης της διαφοράς με εξοδικαστικό τρόπο, με εναλλακτικό τρόπο, με φιλικό τρόπο. Η ΙΑΣ είναι απλά μία διατύπωση. Εκείνο το οποίο είναι πάρα πολύ σοβαρό και το επισημαίνω, διότι τίθεται ως ερώτημα από πολλούς συναδέλφους, είναι κατά πόσον πρέπει να ενημερώνουν τον εντολέα τους οπωσδήποτε και αν πρέπει να υπογράφουν το έγγραφο της ενημέρωσης. Απαντώ ότι ναι, σε κάθε περίπτωση πρέπει να ενημερώνουν τον εντολέα τους, ιδίως διότι μπορεί να υπάρξει μια εθελούσια διαμεσολάβηση. Δεν είναι ανάγκη να κολλάμε πάντοτε στην ΙΑΣ. Πρέπει λοιπόν να ενημερώνεται ο εντολέας για τη δυνατότητα επίλυσης με εξοδικαστικό τρόπο της διαφοράς και παρακαλώ σημειώστε ότι για να είμαστε σωστοί ως επαγγελματίες πρέπει να υπογράφουμε το έντυπο ενημέρωσης, το οποίο υπάρχει όπως ξέρετε στην ιστοσελίδα Διαμεσολάβηση του Υπουργείου Δικαιοσύνης, μαζί με τον πελάτη. Μην βάζουμε τον πελάτη να υπογράφει μόνος του, μην υπογράφουμε μόνο εμείς και επίσης η δική μου άποψη είναι, και δεν είναι μόνο δική μου, αλλά αυτό θα σας το πούμε επισήμως, δεν πρέπει να υπογράφετε το έγγραφο αυτό κατόπιν εορτής. Ξέρω ότι έχει εκδοθεί μία απόφαση μονομελούς πρωτοδικείου, δεν θυμάμαι σε ποια πόλη, η οποία λέει ότι δεν πειράζει, ας υπογραφεί και μετά από την έναρξη της δικαστικής διαδικασίας, αρκεί να υποβληθεί με τις προτάσεις. Δεν είναι σωστή αυτή η απόφαση. Άλλη απόφαση έχει εκδοθεί του εφετείου, η οποία λέει ακριβώς το αντίθετο και εκείνη έχει δίκιο. Γιατί έχει δίκιο? Διότι εάν ενημερώσω τον πελάτη μου, αφού έχει κάνει τα έξοδα να προσφύγει στη δικαστική διαδικασία, να υποβάλει αγωγή, να πληρώσει την αμοιβή μου, να κάνει όλα αυτά τα οποία κάνει εν ώψη της έναρξης μιας δικαστικής διαδικασίας, οι πιθανότητες να διαλέξει τη διαμεσολάβηση ελαχιστοποιούνται πάρα πολύ. Ελπίζω να μην σας ενοχλεί που κάνω λίγο μάθημα, αλλά νομίζω ότι από την θέση μου έχω αυτή την υποχρέωση και απέναντί σας, επειδή διαβάζω πάρα πολλά στα chats που κάνετε στο Facebook ιδίως και παίρνω την ευκαιρία των συναντήσεών μας της Δευτέρας για να επισημάνω ορισμένα πράγματα τα οποία θεωρώ κέρια και σημαντικά. Μετά από αυτή την εισαγωγή, δεν θα σας πω άλλα πράγματα για τη διαμεσολάβηση, ούτε για τον ΟΠΕΜΕΔ, τον οποίο γνωρίζετε πάρα πολύ καλά. Είναι ένας πάρα πολύ σημαντικός φορέας που δημιουργήθηκε από τους κυριότερους κοινωνικούς εταίρους το 2015 και αντιπροσωπεύει την Ελλάδα διεθνώς σε συνέδρια και στο εσωτερικό και στο εξωτερικό και καταβάλει πάρα πολλές προσπάθειες για να μπορέσει να διαδώσει την διαμεσολάβηση στην Ελλάδα, ακριβώς όπως κάνουμε και εμείς, η Ελληνική Ένωση Διαμεσολαβητών, με διάφορες δραστηριότητες, τις οποίες διεξάγουμε. Σε λίγο καιρό ευελπιστώ ότι θα είμαστε σε θέση να σας ανακοινώσουμε και μια καινούργια δραστηριότητα, στην οποία θα σας προσκαλέσουμε να συμμετέχετε. Και κατόπιν τούτου θα σας παρουσιάσω τον σημερινό ομιλητή μας, ο οποίος είναι ο κύριος Phillips, διεθνούς εμβέλειας. Συγγνώμη, ένα λεπτό. Συγγνώμη, αλλά το iPad μου είχε μία αντίρρηση. Λοιπόν, ο κύριος Phillips είναι διεθνούς εμβέλειας διαμεσολαβητής και διαιτητής. Εργάζεται στην πόλη της Νέας Υόρκης και είναι επίκουρος καθηγητής στο New York Law School και διευθυντής του προγράμματος που ισχύει στη Νέα Υόρκη για εναλλακτικούς τρόπους επίλυσης διαφορών. Περιλαμβάνεται μεταξύ των μελών στην American Arbitration Association, στο China Council for Promotion of International Trade, στο CPR, στο δικαστήριο, ας το πούμε, ειρηνοδικείο των Ηνωμένων Πολιτειών, στα δικαστήρια ειρηνοδικείου των Ηνωμένων Πολιτειών και στο δικαστήριο επίσης ειρηνοδικείου του New Jersey. Είναι διοικητικός αξιωματούχος δικαστηρίων του New Jersey και άλλων οργανώσεων. Είναι πιστοποιημένος από το International Mediation Institute και διαπιστευμένος από το New Jersey Association of Professional Mediators. Έχει τιμηθεί από τον Δικηγορικό Σύλλογο της Πολιτείας του New Jersey ως ο καλύτερος επαγγελματίας εναλλακτικών τρόπων επίλυσης διαφορών για το 2018. Ο κύριος Phillips έχει υπηρετήσει ως μέλος της Διοικούσας Επιτροπής του Αμερικανικού Δικηγορικού Συλλόγου στον τομέα της επίλυσης των διαφορών και είναι πρόεδρος για το τμήμα πάλι των εναλλακτικών τρόπων επίλυσης διαφορών του Συμβουλίου του Αμερικανικού Συλλόγου της American Bar Association Business Law Section. Είναι επίσης αντιπρόεδρος, γραμματέας και του CPR Institute. Έχει συγγράψει ή συμμετάσχει στην συγγραφή 7 βιβλίων καθώς και πολλών άρθρων. Ένα πολύ ενδιαφέρον στοιχείο της δραστηριότητας του κυρίου Phillips είναι ότι έχει γράψει και σκηνοθετήσει μαζί με άλλους 4 ταινίες σχετικά με την χρήση της διαμεσολάβησης σε διαφορές οι οποίες περιλαμβάνουν επαγγελματικά, εμπορικά δικαιώματα και δικαιώματα του ανθρώπου. Οι ταινίες αυτές τιμήθηκαν με το βραβείο Best Publication από το κέντρο του Λονδίνου για την Effective Dispute Resolution, το γνωστό στους περισσότερους από εσάς CIDR. Αυτά ήθελα να σας πω, προσθέτοντας ότι το blog του κυρίου Phillips, Business Conflict, περιλαμβάνεται στο Mediate.com και ακολουθείται διεθνώς. Αυτά είχα να σας πω για τον κύριο Phillips, διευκρινίζοντας ότι είναι μόνο ένα μέρος του βιογραφικού του, και το οποίο είναι εξαιρετικά πλούσιο. Και όπως καταλαβαίνετε, ο κύριος Phillips έχει τεράστια εμπειρία, την οποία θα μοιραστεί σήμερα μαζί μας προς όφελος όλων μας. Peter, I welcome you today in this lecture, and I thank you very much for having accepted my invitation to present the lecture to us, all of us, and to give us your experience and allow us to take advantage of it. Thank you very much. Welcome. And we are prepared to listen to you with very big attention.
Thank you very much, Catherine. It is a great honor to have the opportunity to meet with you. And I apologize at the very beginning that I must speak English. I was listening to Catherine explain what a smart person I am and how many things I have done. But if I were really smart, I would have learned Greek by now, and I have not. So I ask I beg your pardon. Before we start, I also would like to tell you how special it feels to meet again with mediators from Greece. it is a very special community to me, and I will tell you a small story. The first time that I was in Athens, it was for a mediation meeting, and I think that was when I met Catherine. It was maybe 10, 12 years ago under the UIA Forum of Mediation. When I was a young man in university, I studied the theater. And I was always amazed at the idea of the Theater of Dionysus and the festivals that would be held and the great works and the great culture that was created for the theater. And soon after I arrived in my hotel, I went up to the theater and I found that there were ropes around it, so I was not able really to do anything but look at it, see it. So the morning of my last day in Athens, I set my alarm clock for 3:30 in the morning. And I walked from my hotel up the hill to the Theater of Dionysus, and I looked around and I went under the ropes. And there I stood. And I recited a speech of Sophocles in English, but still. I recited a speech of Sophocles there in the Theater of Dionysus, and it was one of the most important moments of my life. So when I think of Athens, I think of a very beautiful event that the city was able to give me. So.
We are very sensitive, Peter. Thank you very much for telling this story. I did not know it.
Yes.
Really,
Well, please, I noticed that this is being recorded. Please do not tell the police that I went under the rope. Otherwise, I'm afraid that there will be a knock on the door, right? So.
It is time barred now.
Okay, very good. Okay, so mediation in the United States is very well established, as you know. It has been in all of the courts for 20 years. It is now taught in all of the law schools, and all young lawyers understand what mediation is. We hope many, many young lawyers do. I have been mediating myself for about 15 years, and I realize that there are a lot of good judges and there are a lot of good mediators in the United States, and there are a lot of systems that direct cases to mediation. But there is one link in this chain that is a very weak link, and that is the lawyers who represent clients in mediation. In my state, I am often assigned by the court to act as a mediator, and I walk in the room, and within 1 minute, 1.5 minutes, I realize this will not work because of the lawyer. So what I would like to do this evening is share with you some thoughts about the skills of representing clients in mediation. I understand that many of you act as mediators, but I hope it is still useful to you to share these thoughts. And for those of you who are in practice and represent clients in mediation, I hope this presentation will be especially valuable to you. What I would like to cover is only a few things. We don't have the time to go through every skill and every part of the mediation, but I would like to talk about how lawyers can select which mediator is appropriate for their case, how they prepare the client before the mediation begins to help the client get the most benefit from the mediation. Once the mediation starts, how to start the mediation, how to offer a first statement from your client, and especially how to listen to the statements that are made by the other party. And then assisting the client, coaching the client as the mediation continues, and adding value to the client as only lawyers are able to do, in a special lawyer skill of helping the client to settle the case. So, the question that a lawyer should be asking when they know they are going to mediate is, if I get a mediator who is unsuitable, I may as well not do it. The mediation will take place successfully only if that mediator is the right one. Now, if it has to do with a difficult area of law, insurance, reinsurance treaties, surplus insurance claims, particular physical injuries that involved injuries of the brain or something like that, then you may need somebody who is a mediator who understands that field. This is particularly true, for example, in construction. Construction disputes, which are very common, at least in the United States, very common. Perhaps you don't want a lawyer to be a mediator. Perhaps what you need is an architect or someone who understands the owner, the architect, the contractor, the subcontractor, the zoning regulations that are imposed by the government, someone who knows the way around it, right? Maybe you don't need a lawyer so much as you need someone who understands insurance, particularly surplus insurance if the case involves subrogation or excess insurance coverage. If it really is a question that everyone agrees on the facts, they just disagree on whether the law imposes liability, that's all. Well, maybe you want someone who used to be a judge and now they are retired, but they know the law very, very well. And if there is no dispute on the facts, having someone who is very, very experienced in the way lawsuits usually work out might be a very effective mediator. It depends. Now we move from understanding the subject matter of the dispute to understanding the process of mediation. Obviously, you will probably want someone who is trained. You will probably want someone with a good reputation. But most of all, whether through subject matter or through process, your client must trust this person. There is a saying in the United States, where the rubber meets the road. You know, when in the car, it's the point where the tire is right on the road. In mediation, that is trust. Without trust, your client will not gain the opportunities that mediation offers. So, more than anything else, is this someone your client knows or has known of? Is this someone in whom your client will accept their advice? A better question, by the way, is the other party's trust. I don't know if you have met a man in General Electric in Firenze named Michael McElrath. And Michael McElrath, when he was with General Electric, had a rule about mediation. Anytime he represented General Electric in a mediation, he was asked the other side, do you have someone in mind who you would like as a mediator? And they would say Michael would say, that's fine with General Electric. That's fine. Why? Because more important than anything else is that the other side feels comfortable. The other side trusts that mediator. Michael, as General Electric, he knows his way around mediation. He can handle this, and General Electric is used to mediating a lot. Not true, the other side. So the main criterion for a mediator for Michael was, does the other side trust this person? Why not get on the telephone and speak to him? It's not like it's a judge or an arbitrator. You could speak directly without the other party if you want to. Go ahead, call them up, find out what kind of person it is, right? How expensive they are and whether they're available to do it. The point is that you are not looking for the expert in the field. You are not looking for the greatest lawyer or the most perfect judge. You're looking for someone who will coach, just like a football team, like Barcelona. You want to coach for Barcelona to be there saying, well, try this, try this, try this. And in order to do that, you need a trustworthy person that your client gets along with and that the other party trusts. By the way, in my state, I have almost never had a lawyer call me up and intelligently ask me questions about whether I can mediate well. They don't even do the first step. They don't do the first step of intelligently selecting a mediator. So you have selected the mediator. Now it is your job to prepare the client. I think you will discover that often the client prepares you. The client gives you insight into the client's business and what is at stake and what the opportunities are and what the risks are, okay? You remind the client that the mediation there's nothing at risk in the mediation. It is only negotiation. It is only a settlement discussion. There are no judges there. There's no record there. It's not like an arbitration. It's not like appearing in court with the person writing down everything you say. The client needs to hear that. The client needs to understand that this is just like a negotiation session, except someone else is in the room to help. That's all. That's all it is. So your client should not be apprehensive or frightened. Remember, in court, we will be trying to win. We're not trying to win in this mediation. We are trying to settle this dispute. You know, we're trying to make the dispute go away. If we are successful in court, we will have a judgment. But if we are successful tomorrow in the mediation, there will be no more lawsuit. It will be gone. That's what we're looking to do. We're trying to get rid of this dispute. Tell me about your business. Talk to me. How did this arise? Was this person an employee, a stockholder, a member of the board, a vendor, a customer? How does this dispute fit in with your business? Putting it that way, you are then able to say, in the event that the lawsuit continues, okay? If we are unsuccessful tomorrow, and this lawsuit continues, what effect will it have on your business? What's the best possible thing that could happen? What's the worst possible thing that can happen? I would just like to hear from you. How important is it that we settle this case now? Can you afford a lawsuit? Do you think that your business will be better because of the lawsuit? What about your reputation? I just need to know how important it is to you and to your family and to your stockholders and to your employees that we get rid of this. How important is it that we solve this? This is what we call in psychology, right, loss aversion. It has to do with whether this person is willing to live with risk. I confess to you, I am highly loss averse. I do not enjoy risk. When I save money, I either put it in the bank or I put it in some very safe. I don't gamble with money. I don't, you know what I mean? I just don't deal with that. Now, other people, especially business people, are much more willing. So you as a lawyer, some clients are willing to live with risk. Some clients would like risk to go away. In order to represent that client, you need to know that. You need to have a sense of how your client wants this to work. Impress on the client that the other party, the actual person, will be there. Forget the lawyer and the mediator. The actual person will be there, and you have an opportunity now to talk to her. You can explain to her how this happened. If you say that you apologize, you can apologize. I'm sorry that it happened, but I don't owe you any money, you know. It is the first and probably the only opportunity to sit with the other side until you get actually to the court, until you get to trial. This is a great opportunity. You'll be able to listen to what she says, and you'll be able to tell your story to her so that she understands you. She may think that you are crazy, or she may think that you are mean. Well, I know you. You are not crazy and you are not mean. Tell her that. Just tell her how this happened. You also have the opportunity to learn from this mediator. The mediator is very well trained in how negotiations go and how bargaining goes. So we have the opportunity to use this mediator's skill. If you feel that someone is trying to force you to answer a question, stop. There is no judge here. There's no one who requires you to talk. And if you prefer not to talk, don't do it. On the other hand, if you feel that it's important to be understood so that people understand what business you are in and why it is unfair that this happened, certainly go ahead. No one will interrupt you. Okay? It is confidential, but simply because something is confidential doesn't mean that you should just talk about anything. Be careful. Be careful. You know, we are always prudent, aren't we? Prudent business people, prudent lawyers. We always need to be on our guard. But nothing that we say will ever be told to the judge. I mean, you know, that will not happen. Now, you see that all of these ideas, okay, are there to explain to the client that this is a business negotiation, that you don't have to worry about the law one way or the other, that this is not the trial, that the important thing is to find out a solution to this problem that makes business sense for you. So tomorrow, we're not going to be talking about the law. We're going to be talking about how to resolve who owes who, what kind of money. That's what we'll be discussing. That alone, okay, is something that most lawyers do not understand. I would like to show you a tape of, let me see. I'm having trouble getting this back on. Let me see if I can do this. Excuse me just a moment. Yeah. I usually think I'm very, very clever, you know, but perhaps now I'm not being so clever. Ah, there it is. All right. This is an example of a bad way to start a mediation.
Before we begin, I want to talk a little bit about my role and how I generally do things.
Catherine, can you hear this?
The way I usually begin is to ask the people who brought the complaint that gets us here. In this case, I think that would be you, Ms. Basson, and you, Mr. Faheri. Tell us a little bit about the situation as you see it, and perhaps more importantly, how we might move forward to begin to get this resolved.
Well, thank you, and thank you for the opportunity to be able to present this case to you. What we're really dealing with...
Let me just make an observation to start with. She asked the party to explain what happened. So did the party explain what happened? No, the lawyer started to talk.
...is incompetence on the part of FAF. That's really the underlying set of circumstances that we're going to have to deal with in the course of the day. They overpromised, they underdelivered, they convinced us that they could do a job. They failed utterly. Basically, they lied to us, and they did it repeatedly.
Now, you see why I call this a very bad a very bad opening statement. Anybody who, I hope, by the way, you were able to see it and to hear it okay? Yeah. So Maria, do you have a sense of why it is that I think that's a terrible way to start a mediation?
You said before, because the lawyer started to explain the situation, and because he started to do it very, not in a way that he wanted to resolve the situation,
exactly.
but in a way he wanted to. He was offended. How can I say it? He was.
Yes, we only saw about 1 minute, but what, he called them incompetent, he called them a liar, right?
Exactly.
He called them fraud, he called them all these names. Now, there is no judge in the room, so he's wasting his time. Nobody cares whether they're incompetent or not. We're trying to solve the case, right? So he completely misunderstood why he was there, and began to pretend as if he was making a statement at trial that the other side are bad people. I don't know about you, but I see this every day when I mediate. Every day. Every day I see lawyers, who behave as if they are in front of the judge. And all they do is call people names. Do other people have thoughts on that?
Can I say something?
Yes, please.
It's very difficult for me when I mediate, to control lawyers.
Ah.
I mean, they start to speak. They want to speak from their client, and they don't let the client express himself or herself.
I agree. The most that I can do sometimes is say, may I have the opportunity to hear from your client? And the lawyer, of course, will say, no, this is my mediation, and I'm, you know. It's very difficult to teach people lessons in the middle of a mediation, don't you find?
Yes. And can I say something?
Yes, please.
Well, I don't like to say that, but usually in Greece, the lawyers, we are kind of aggressive. The lawyer you just showed us is a typical type of lawyer that we every day have to deal with in court, in negotiations, wherever. And this is a little that makes the whole thing of mediation a little bit difficult, because it's not the law after all, but it's the culture that we have to fight against. And the lawyers are not educated enough so they can be helpful to their clients. And according to me, when I mediate, the lawyer usually is very aggressive. Either he says nothing, he's not helpful at all to just let the situation go a little bit better.
Yes, yes. The points that I am making are best made to the lawyers. It's difficult for me to speak to you mediators about what you can do to make sure that the lawyer does the job he's supposed to do. Nevertheless, I hope anyway, I assume that many of you do appear in mediation, or when you are speaking as mediators before the mediation, you could suggest to the lawyer, you know, I probably will want to take advantage of your client's being in the room to hear him, so that the other side has the opportunity to hear him. Would that be okay with you? Do you know?
Mm-hmm. So do you suggest a good idea is to have a little chat, a little a talk
Yes.
Before the mediation with the lawyers, and maybe
Absolutely.
try to educate them just a little bit about the whole,
Yes.
whole culture thing, because
Yes.
we are talking about the culture and not just a procedure.
Yeah, culture, but also I think we have to say culture and legal training, right? Yes. It is not a process that that most people learned when they trained as lawyers. So we need to help them learn a new thing. Let me go on because I want to make sure that we get in as much as we can. As I say, who is the one who should tell this story? Is it the lawyer or is it counsel? Once they decide whether it should be the lawyer or the client, that's up to them. But I hope that they speak to the other side. Very frequently, the lawyer or the client will talk to me as a mediator. And I don't have the heart to tell them, I don't care. I don't care about the story. The person who cares about the story is sitting right across the table from you. Talk to them, right? It is intended for the other side. And as a lawyer, you say, now, what do I want the other side to hear? What do I want them to understand? I don't want to talk to them about the law because the lawyer is sitting there and he will argue with me about the law. But was it green? Was the light green? Or was it raining? Was I minding my own business and something happened? You know what I mean? What is the narrative? What is the story? From the client's point of view, what actually happened? So you hope that they tell a story, a narrative, not a legal argument, a narrative about what happened that day, right? And based on what happened that day, the lawyer can say, for that reason, I thought it was a reasonable thing to say that this suit violated this code, you know, right? And we're very confident that it did. But obviously, it's much better for us if we can resolve this today rather than spend the time and the money to resolve it in court. And that's why we're here. So I would like now to hear your story. Particularly, I'd like to know, do you remember that the light was red or that the light was green? You know, and was it raining or snowing? Because I don't know what we agree on and I don't know what we disagree on. And it would be very helpful to get the benefit of your own clarification. I assure you, I'm not going to argue with you. All I want to do is hear your story, okay? The audience is the other side. The client gives a personal perspective. The attorney notes that there are certain facts that we're not arguing about, right? There are certain facts that we are arguing about. So let's only worry about those. Let's not talk about all the rest of it. Right? Again, the way I looked at it, the appropriate part of the code was this part. Now, I could be wrong about that, but that was my best sense of how we should go on. And then the client explains why they would rather settle the case than take their chances of going forward. And that generally speaking, they need to have their job back, or they need back pay, or they need a different supervisor at work, or they need, you know, generally speaking, what it is they're looking for. So to me, the ideal way for an opening statement to take place is that it starts with the client telling the story. Then it goes to the attorney who explains the legal basis for it. Again, not to argue about it, but just to explain the logic of it. And then go back to the client saying, I would much rather pay a little today than pay a lot tomorrow. Let's work something out. So the client gets to own the process. The other side gets to understand, they don't have to agree, but they at least understand why the party is acting the way they are, right? And it sets the tone for a business. It sends business messages. It creates a non-legal business relationship for the way the conversation is going to take place, right? And the lawyer is there to supplement a little bit. Now comes the great opportunity. And this is the opportunity that so seldom is taken. You get to listen to the other side. I will tell you a story that is from an American Indian tribe, the Iroquois tribe. It was too cold in the forest. Bear, crow, coyote, rabbit, and wolf met to discuss what to do. Crow said they should gather sticks for nests. Wolf said they should move away to a different part of the forest. Coyote said they should find the source of the cold and kill it. Rabbit said they should burrow underground and wait for the cold to end. And the four of them argued over whose plan was the best plan. Bear did not speak. After a while, Crow said to Bear, "Why do you not join us? You are as wise as any of us. We wish to hear what you say." And Bear said, "I already know what I think, but I don't know what you think. In order to learn that, I must listen. It doesn't help me to say what I already know." Now we have the opportunity to listen and learn things that we don't know, okay? You can listen to their story. Does that story make sense? You can see the party. At court, will that party be believed? You can listen to the lawyer. Are there any legal arguments you haven't thought about? Are there some legal approaches that you should learn from? You listen to the information. Is there anything new there? You can ask a question and say, I thought this happened at noon, but you're saying it happened at 3 in the afternoon. Is that the way you remember it? You can find that they have an invoice due next April that they don't have the cash flow for. You can find business issues, business problems, business priorities that the other side has that you weren't aware of before. You can find out things they need that you have. They don't know you have them, but you can find out ways that perhaps you could trade some things that you didn't know before if you listen closely. And you can assess their answer to the question you asked yesterday. Yesterday, you asked the client, in the event that we don't come to terms today, what's going to happen? You can begin to understand what happens to the other party if the other party doesn't come to terms today. And this is the concept of leverage. In any negotiation, one side has leverage over the other side. How do you know who has leverage? And the answer is, whoever has the worst BATNA, whoever, in the event that the negotiation fails, who gets hurt more? The other guy has the leverage. The leverage is to the person who can afford for the negotiation to fail. And if you realize that the other side is in worse shape than you are, you have the leverage in the negotiation. You can learn this only by listening closely and asking questions. There was a judge in a panel in the US Supreme Court. There were 2 US judges. And one of them in this presentation for the Bar Association was explaining a rationale. And the second one said, well, I never heard of that before. I never thought of that rationale before. However, it's terrible, and I'll tell you why it's so bad. And the first judge said, well, if you had never heard of it before, I wish you'd think about it. I wish you'd think about it before you decide, right? You can't understand without listening. Moreover, listening, there's a part of listening that is almost like theater, because in addition to listening, you need to look as if you're listening. You have to be seen listening. You have to show that you've been listening by asking intelligent questions about what you've just heard. You ask why that happened, and you ask what happened next. And you give it the weight, and you be seen to be giving it the weight. And you hope that your client is listening, and you hope that your client is willing to be changed by what they hear, okay? You can say to your client out in the hallway, what part of that do you agree with and what part didn't you? Then you ask, do you think that a judge might agree with them? What are the chances that the judge will agree with their story? If the judge agrees with their story instead of yours, what happens to you? Right? You're not asking the client to change their mind. You're asking the client to consider what happens if the judge changes her mind. Now we have a problem. Now we have a problem. Okay? I think I'm going to stop there because we've gone on a bit long, and I want to have the opportunity for us to discuss what we've talked about. The underlying point that I'm trying to make is that from the point of view of someone who is representing a client, mediation has tremendous opportunities, huge opportunities especially to receive information and to receive an understanding of the consequences of the negotiation, and to be able to adjust your negotiation style based on what you've just heard. Almost nothing in mediation has to do with persuading somebody. Instead, it has to do with learning new facts, learning new law, learning whether the other side is worse off than your client is, and allowing those perceptions to drive the negotiation process. In court, you learn all those things too late, if you learn them at all. Mediation is the opportunity to explain, but then much more important, to listen and make adjustments. Now you would think, I mean, it's not, I'm not teaching you brain surgery, right? It's not this is something that you need to go to school to understand or anything like that. In fact, any businessman already knows this, right? Any businessman already knows how negotiations work and how a smart negotiator listens more than he talks. Every businessman knows that when you enter a negotiation, the less you talk, the more you learn. It's only lawyers who are so stupid that they go into a mediation thinking, bah, 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 bah. So that is my presentation, or at least a group of suggestions on how lawyers might be encouraged to approach mediation as a unique, special, distinctive process, not like any other process. It's an opportunity to learn more about your case, and it's an opportunity for your client to get what the client really needs. Don't worry about whether you win in court, but to get what the client really needs. Catherine, I think I have been talking enough. I wonder if anyone has any other discussion or any observations they would like to make.
I have a question, if nobody else has for the moment. You said that mediation is a great opportunity for one party to listen and to gain information from the other. But how do you deal, not as a mediator, as a lawyer of the other party, who understands that in fact this is the whole tactic of the other one? They don't care about mediation, but they are only there to gain this information to use it in another level. How can you avoid this?
I don't think that you can.
Mm-hmm.
I don't think that there is anything that will be discovered in mediation that would not be ordinarily discovered. I mean, it's just that it'll be discovered later. Any time that you negotiate, you decide what not to say, what to withhold, and what it is that you want to say. Sometimes, for example, in negotiation, you might tell somebody that it's very, very important to you to get a lot of money. And actually it's not. You're just saying that in order to mislead them and to get what you really need. You can do that in mediation. You can misrepresent, just like in any negotiation. So you enter the mediation as a client or as a representative of a client with intelligence and skill and with negotiation skills. It's just that you don't worry about persuading anybody, which is what you do in court. There isn't anyone there you need to persuade.
Okay, thank you very much. We have a question from Mr. Envalomenos. Do you want to read it, or do you want me to read it for you? It's on the chat.
No problem. You can read it. You can. Thank you. Hi. Okay. I could tell it to you. We've been told. First of all, many thanks for your presentation. Valuable information to us. We've been told that there is no accreditation of mediators in the US. If this stands, my question was, how do lawyers and prospective clients of mediators and parties choose a mediator, and how can the qualifications of a mediator be traced in advance and checked so that to imply what you said at the beginning, to choose the appropriate mediator in the circumstances of the case? Thank you.
Right. Well, when someone chooses a lawyer, how do they do it? Look, I'll give you a better example. We had difficulty with our plumbing in our house last month. It was very bad because it came from the toilet and the pipe was broken. So we had this horrible, horrible water that was going down the side of the house. It was very bad. We needed a plumber. Now, how do we find a plumber? We asked the people in our neighborhood that in houses next to us if they had hired a plumber, and who it was, and whether they were expensive and did they do a good job. We looked up in Google to find what plumbers had good businesses here in my town, so that I could learn who had a good reputation. I called people up and asked them to come over and look at it and tell me how much they thought it would cost. And so I had a sense of whether they were any good. I don't mean to say that mediators are plumbers, but it's the same way that I get a dentist for my teeth, the same way I get a doctor, the same way I get a lawyer. I ask around and find who has a good reputation. In the United States, there are many, many mediators. And you can tell immediately if someone simply went to the store and had a card made up and now suddenly they're a mediator. Or if you go to my website, you will see where I went to school and how I was trained and what I have done and how many times I have mediated and who will be a reference for me and things like that. So just because, as I said in the beginning, the mediator you want may or may not be a lawyer, may or may not be trained. It depends on the nature of the case, but there should be more than enough information available so that you can decide, do I want this person in my house to fix my water? Or do I not want this person in my house? You and I have both done that. And I think we have usually, sometimes we make mistakes, right? But usually it works out okay.
Thank you. So I understand. So the profession is unregulated, and therefore, there's any statements and public statements on social media, website, and so on are subject to the general regulation on misleading statements, misleading advertising, and so on.
Yes. Yeah, with the exception of the court. In order to be a mediator who the court will recommend.
Yes.
Now, you must take all these hours of training, you must have practice mediation, you have to have experience, you have to have someone who will recommend you, you know, that's a whole different thing.
Okay.
So in the New Jersey state courts, New York state courts, in the United States Federal District Court, they all have lists of mediators on their website. And to get on that list, that's a big deal.
Thank you.
I will just, Demetrius, I will add just one other thought to that. there is too much training and not enough doing in my. There are too many people who are happy to take your money to train you, but there are not enough people who will get you work. Catherine, does that make sense to you? Do you have that experience too, that there are a lot of people who train mediators?
Indeed. And I find, I'm sure that you remember, Peter, when we have spoke about this in Praha in 2013. It was one of the topics.
Yep.
And we spoke about whether it was appropriate to train a lot of people in a country which has not many cases submitted to mediation.
Exactly.
And the answer was no.
Exactly right. We were in Vienna once, and I learned that in order to be listed as a mediator in Vienna, in Wien, you need to be trained for 224 hours.
Indeed.
And the person who was telling me this, I was astonished. And I said, well, how much mediation do you have? And he said, oh, we have none. I understand why. No, there are very few mediations that fail because the mediator was poor. Mediations that fail usually fail because the clients don't want to settle. The next reason that they fail is because they were conducted too early or too late. And the next reason that they fail is because the lawyers refuse to allow their clients to settle because they think they can make more money if it doesn't settle. And the last reason why a mediation fails is because the mediator is clumsy or doesn't know what she's doing. It doesn't happen. It doesn't happen. Am I saying the wrong thing?
There is a question from Mr. Livadiotakis, but I cannot really understand it. So could you please explain it, Mr. Livadiotakis, on Zoom? Κύριε Λιβαδιωτάκη, μπορείτε να μας εξηγήσετε τι ακριβώς θέλετε να ρωτήσετε?
So, Catherine, are we about finished? How is it? How are things going in mediation in Greece? Is there more mediation than 5 years ago?
No, I can tell you that since 2019, as I've said you before we started, Peter, we have a new law which provides a mandatory first meeting of mediation. The aim of this is to lead to a full mediation. To be frank, up to now, this is not a success, but still lawyers and especially people get accustomed to what is called mediation. They start to be informed about mediation. And since this new law is very new, it is not even 1 year and a half, we hope that after 1 year or two, mediation will really start. As we said before, Peter, before we started, mediation in family cases. There are more cases, family cases submitted to mediation than other cases, business cases, for instance. But the thing is that at present, we are in Greece more than 2,000 mediators. In 2011, when we first met, Peter, we were not 100.
Right.
And now we are more than 2,000.
Well, we don't have to worry about that part of the equation then. All we need to worry about now is having people who want to settle their case. I have a suggestion for you. Follow the example of the United States. In the United States, the courts are very slow. They're very expensive. They are very cumbersome. And if you file a case in a federal court, you will not see trial for 5 years, okay? Now, that's a good way to mediate. Have a terrible court system. Then mediation becomes very attractive. The worse your courts are, the more attractive mediation is. No, I am joking.
No, it's true. It's true, but first people have to become familiar with mediation, one,
Yes.
and second, admit that mediation is as efficient as the court trial is.
Oh,
Because
certainly.
many people think that because a mediator does not render any judgment, he's not as efficient as a judge, which is not true. There is not a judgment, but a decision regarding the solution of the case.
Right.
And this solution is much more important because it is the one the persons themselves, the parties themselves, have selected it.
Right, right. Well, as I said to you in the beginning, the only thing that would be more fun than this Zoom meeting would be a meeting just outside the Theater of Dionysus sometime. And perhaps after the COVID is finished, next year, we could all find a way to sit in a round circle in the middle of the city under a tree, huh? And we can have some bread and have a little wine and tell stories to each other about our mediations. Okay.
This will be wonderful. Let's hope that it will be so.
Thank you all very, very much. Thank you for the invitation, Catherine.
Thank you for having accepted it, Peter. And I would just like to add that today we have the honor to be followed by our president of the Commission of Legal Matters of the Central Commission of Mediation of the Ministry of Justice. This subcommission is competent in order to answer questions which are submitted to us. I say us because I have the honor to be a member of this commission. We answer questions and we publish them on the site of mediation. And this is very important. And I want to thank once more our president to be here tonight with us. It is not the first time. And we are very honored. We are also very, very honored, Peter, for having you together with us today. It is a really very big honor and a very big pleasure to have the opportunity to see you again, because we've changed emails, but today I have the opportunity to see you again. Thank you very much. And I look very much forward to see you again in Athens.
I hope so.
And to go to the Acropolis.
Yes.
Legally.
Thank you very much. Bye-bye.
Very much.
Bye-bye. Bye-bye.